The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons have any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States.
Good morning. Michael, I don't see counsel on my screen. Should I see them?
Morning, Your Honor.
Good morning. There we are. Mr. Ross, you may proceed. Good morning.
May it please the court. If you ask 5 different people for a legal opinion, in many cases, maybe even most cases, you're going to get 5 different answers. Not so in this case. James Nathaniel Bryant murdered Corporal Dennis Lydon of the Horry County Police Department on June 5th, 2000. He beat him unconscious with a steel flashlight. He took his service weapon and he executed him on the side of the road. Mr. Bryant's guilt is not in question, and a jury of his peers sentenced him to death. At his trial, the issue of one juror's hearing impairment was repeatedly and thoroughly examined. And although these—
Mr. Ross, if I could interrupt you before we get too far into the meat of things, this is Judge Agee. I'm not on the phone, not up on the screen. I wanted to ask you a preliminary question about one of the issues in the supplemental briefing that the court asked the parties to address, which was whether the doctrine of invited error would bar Mr. Bryant's claims here. As Mr. Bryant points out, it does not appear that the state raised that point below or even in the appellate briefing here. So my question is, have you waived that claim? And if you have, does the court have any authority to consider it sua sponte?
Your Honor, we have not waived the claim, and the court does have the authority to address it on its own sua sponte, and the precedent for doing that is Wilson v. Lindler. That was a case from the Fourth Circuit, 995 Federal 2nd at 1262. That was the panel opinion that explicitly stated that the court was raising invited error doctrine on its own without the state having raised it below at the district court level. That was affirmed by the en banc court in Wilson v. Lindler as well. Now, Mr. Bryant—
Counsel, it's Judge Harris. Can I ask you, in that case, had the this is sort of an unusual case in that both the government and the defense effectively invited this error. The government withdrew its request to remove this juror. So in the case you were talking about, had both parties sort of participated in getting this error unexamined?
Yes, in Wilson, that was precisely what happened. You had the solicitor in that case and the defense attorney discussing what were the appropriate jury charges to go to the jury. He was charged with burglary second degree, and in South Carolina, you can get to burglary second degree 2 different ways. Now, the state only charged one way initially in the indictment in Lindler, and the parties discussed what would be the appropriate jury charge, and both parties presented jury charge.
Mr. Ross, this is Judge Diaz here. Was Wilson a direct appeal or a post-conviction case?
It was a post-conviction case that this court was considering.
I'm sorry, I didn't hear that. What did you say?
It was a post-conviction case that this court was reviewing on federal habeas under 2250. It was not a direct appeal, and the court addressed the issue on its own, sua sponte. And for good reason, because the invited error doctrine is not just an issue of state law. It is a federal doctrine that's recognized throughout the country and in this court as well. Mr. Bryant noted in his supplemental response brief that the invited error doctrine is a state procedural rule, and as such, the state had a duty to raise it below. But this court has explicitly held in another case, Yeats versus Angelone, which Mr. Bryant cited in his brief, that there are issues that transcend the particular issues of the parties. Those issues are—
Right. So, Mr. Ross, wouldn't the prosecution agree that the integrity of the judicial system and justice is such an issue that transcends invited error and should be an exception
particularly in this case, where the prosecution recognized that this juror could not hear all of the evidence?
I would disagree with that factual assessment. The solicitor at the end of the day flat out said this juror was.
Okay, at the end of the day, what did the solicitor say 4 times before the solicitor said, oh, well, it's good enough, nothing to see here? Didn't the solicitor say 4 different times, this juror cannot hear?
The solicitor is noting what he feels are concerns. He also testified at the bar that after deliberating on the issue, and recall, this was a matter that went over the course of several different days. After deliberating on the issue, he didn't think his objection had merit, that he realized in looking at the standard that you don't have to be a perfect person to sit on the jury. You can even be blind.
So how much of the evidence could a juror not hear because she was deaf in a death case, in deciding whether to sentence somebody to death? How much does the prosecution think is enough for that juror to hear?
I think
51% of the evidence?
First off, I know the Supreme Court hasn't identified a standard to separate.
I'm asking what the prosecution thinks would be just here.
What I think is just is how the PCR court analyzed the issue. Is there a showing that this juror missed material testimony?
Tell me, Mr. Ross, how does someone know what they have not heard?
This particular juror can use not just her ears, but also her eyes. She's watching the juror.
How does the prosecution know what she didn't hear? How much did she hear?
I'm sorry?
How much of the guilt phase did she hear?
She heard material testimony. She was asked.
How much? How much did she hear of the material test? Actually, how much of the material testimony did she miss? How much did she miss?
She did not miss any material testimony.
How do you know that?
Because we asked the juror directly. The juror was asked at any point, did you turn your attention away and then realize you hadn't turned it back fast enough? And she was asked, well, at that point, do you think you missed anything? And she said, well, at one point I thought maybe.
She says she may. Here's what the solicitor actually said. She's admitted that she may have missed evidence at the guilt and at the penalty phase. Your Honor asked her about this blue dress, and I think, this is the solicitor, I think clearly she's not catching everything and should be removed. So how much is enough for somebody to hear at the penalty phase or to miss? 51% of the evidence? Is that what the state thinks?
That's a quantitative standard, Your Honor. I think material testimony is an appropriate standard. That's a standard that
and how much of the material evidence at the death penalty phase did she miss?
She missed no material testimony, Your Honor. That was her words, and there has been nothing to
Okay, I'll find the transcript and read it to you here in a little bit, but somebody else might have questions.
Let me ask you this, counsel. Isn't the state of her hearing and how much the juror heard a factual question?
Absolutely, Your Honor.
I mean, it's something for the PCR court, or it's something initially for the trial judge to monitor. But this kind of thing is made for a PCR court rather than a federal appellate tribunal, is it not?
Your Honor, I would say that there are 2 levels of deference involved here. You have deference to the trial judge's decision there on the spot. The law recognizes that the trial judge is in the best position to assess juror qualifications, and that's for good reason. The trial judge can see and hear things that don't make it into the...
But all I'm saying is that the state of her hearing and the degree of her comprehension and the rest, I wonder why that's not a question that's intensely factual in nature and would have to be subject at a minimum to a clear and convincing standard to have it overturned. I mean, the question I have here is whether or not we're going way beyond what our proper role is.
You're absolutely right, Your Honor. It is an inherently factual inquiry. And it's, again, the law recognizes the trial judge is in the best position to do that. The law also recognizes that there's double deference involved when you're under 2254.
So tell me a little bit about the PCR hearing. Was the juror called in?
The juror was in the courtroom. She had a subpoena in her hand. She did not testify for whatever reason. Instead, Mr. Bryant called the juror's husband, and the husband provided some anecdotal evidence to support his claim. Mr. Bryant was also given the opportunity, and he offered an affidavit from a family physician on the issue. He didn't present any objective metrics at that PCR hearing. He did not come into court with anything saying this juror can only hear X number of decibels or her hearing is X percentage below the national.
Mr. Ross, can I ask a question? This is Judge Diaz. You were asked by Judge Thacker what the state believed to have been the amount of material testimony that the juror may have missed. But whose burden was it at the PCR court level to make a showing as to whether or not the juror missed material testimony?
It's always the applicant's burden to prove his case in PCR. So Mr. Bryant had the burden to show that material testimony was missed. That's just a fundamental burden of proof in any PCR that you have in our state. And he simply failed to meet his burden. He was given the opportunity to present evidence, and he didn't present sufficient evidence to show material testimony was missed. And he could have done that. He could have shown, Mr. Bryant could have shown this juror missed material testimony. He could have shown that at trial when the juror said, yeah, there was one moment where I looked away, and then when I returned my attention, it took me a second, and then I realized I was following along.
Mr. Ross, I still don't understand what that proof would have been, other than, I mean, her doctor says she's deaf. She indicated multiple times during trial that she could not hear some of the testimony. And the solicitor, in fact, said at trial, I don't think there's any way to establish with absolute certainty how much she's hearing.
She is not saying she couldn't hear anything. She's repeatedly asked, are you getting everything? And she's repeatedly telling the judge, yes, ma'am, I'm hearing everything. He indicated
what?
That
you think she repeatedly told the judge she was hearing everything?
Periodically through that trial, the judge is asking her, ma'am, are you catching everything? She's saying, yes, ma'am, I am. The judge followed up with the
You're leaving out some pieces of that transcript, I think, when you're saying that she said every time that she heard everything. You're not saying that, are you?
She's repeatedly asked, are you hearing all
Wait, were there times that she said she missed evidence during the trial?
At the end, and Your Honor, let me explain. At the end of the final colloquy with that juror, she's saying at one point she turned her head away and she returned her focus. And she admits, yeah, she might have missed some testimony, but I thought.
Are you saying that she only said one time that she missed testimony?
At that final colloquy,
Okay, one time at the end, but I'm talking about throughout the trial. She indicated, there were indications she wasn't hearing things, correct? That she was reading lips or trying to read lips, that she had missed things.
Yes, I am following along. I can read lips. At one point, the defense attorneys actually pick up the podium and move it closer to the juror so she could actually ensure she could see. Yes, Your Honor.
Counsel, can I give you a chance to just address, I mean, there are many troubling parts of the transcript, but the part that troubled me maybe most is when the judge is talking to the juror, face to face, a few feet away, and raising her voice, and the juror still can't follow what she's saying. And so the judge says, I'm noting she's indicated she just flat did not hear, and I was looking directly at her and talking, and even now she's having difficulty hearing me, and I'm raising my voice, and there's been a lot quieter voices than mine during the trial. What should I make of that? The judge is a few feet away from her, raising her voice, And the judge says she still can't follow what I'm saying.
Your Honor, what I would ask is how many lawyers come into this very court and have to ask a judge to repeat himself? It happens all the time.
But very rarely does the judge then say, oh, wait a minute, I have a serious concern that this person cannot follow the testimony in this trial. That is very rarely the follow-up, but it was here, when the judge says there have been a lot quieter voices than mine during this trial. That is very rare in my experience as a judge.
Well, and I can tell you, when a judge calls you on the carpet, isolates you from the remaining jury panel, puts you on the spot, and asks you a question, you may look the judge directly in the eye. You may know that there are words coming out of the judge's mouth, but your mind is going a million miles a minute, thinking about something else. And I'm sure that
Mr. Ross, can I follow up on that? So the question is whether, and that is admittedly somewhat troubling, but you can't take that comment in isolation. You have to take the entire interaction of the juror throughout the proceedings. And I think, as you pointed out, jurors by nature are very nervous when they come into a courtroom. Early on in the proceedings, there was some confusion on the part of the juror when she was being asked about the burden of proof and those kinds of things. And I don't find that to be, at all unusual for a juror. The question is whether, taking the transcript as a whole in context, there's been a showing that she missed material parts of the testimony. At one point, you seem to be arguing that she missed nothing. I don't think that's accurate, but the question is whether or not she missed so much that she wasn't functioning as the kind of juror that the Constitution requires. And at least on this record, whether or not the PCR court's findings were as complete as we would want them to be, the question is whether or not the evidence supports or a finding of that the juror missed material parts of the testimony. Isn't that right?
Yes, Your Honor, that's right. That instance with the juror is one piece of evidence in Mr. Bryant's favor. It is not enough. It is not a smoking gun that can show a contrary conclusion reached by the PCR court. Subjectively.
I mean, there's more than one piece of evidence on the fact that she can't hear or could not hear some of this testimony. What is your response to the solicitor saying at the guilt phase, I don't think there's any way to establish with absolute certainty how much she's hearing? Is it the prosecution's position that that is not a problem in this death penalty case at the guilt phase?
I think you can prove how much you missed, if anything. It's simply
how?
You call her to the stand.
Other than to bring a doctor in and say she's deaf. Her husband said she's deaf. She said throughout the trial she couldn't hear at points. The solicitor repeatedly was concerned that she could not hear. And the judge said in the guilt phase, she just flat out could not hear me. So how is it?
Put her on the stand. Ask her what she remembers from the case. And remember, in this particular case, Mr. Bryant called witness after witness after witness after witness in mitigation. They are all hitting nearly identical themes in mitigation. You could ask that juror, what do you recall from Mr. Bryant's case?
Okay, so she only needed to hear one of the witnesses because they all said the same thing?
That is not what I'm saying. I'm saying Mr. Bryant could have made his case. He didn't call the witness. This is not an impossible task. It gets much more difficult the longer you wait. He could have done it right there on the spot at trial and asked the juror, hey, who was testifying when you turned your attention away? He could have put her on the stand at PCR.
Mr. Ross, may I ask you a question?
Yes, sir.
Well, we know that defense counsel didn't want to get rid of this juror. I mean, that's beyond peradventure. There's no question about that. So we know why that policing didn't happen. But isn't there a question and follow up in terms of what Judge Harris was asking about at a point where, and Judge Diaz too, I think the question is that a juror can be so intrinsically incompetent, and I don't mean that in a pejorative sense, but that she's not qualified to be a juror. It's not a matter of trying to question her about how much you heard about each witness. For example, 15 mitigating witnesses had testified when she went through the person wearing a blue shirt, please stand up. There's a question whether or not somebody nudged her. Then after he had 30, then another test. How many cases do you have a judge trying to find the physician to see whether or not a juror is qualified? It's just too important, particularly in a death case, to try to hang on to a juror that the record has established has a serious problem with hearing. That's what I'm talking about. Counsel clearly wanted them, but you can't get together and decide that the Sixth Amendment doesn't matter in terms of a jury in a death case. Can you answer that? Isn't it something that's important about a juror, each of them, to be qualified?
Mr. Bryant is in control of his own destiny. It was not just his attorney making.
He's not in control of the Constitution. You can't, and there's something about he's not in control of the Constitution in the sense that a jury speaks about our society, a rule of law under the Sixth Amendment. It's not just, well, because they came out and said, well, we've decided that she heard enough. Well, how could they have possibly gone into a bench conference and in there the three of them decided she heard enough? What did they do? They had no tapes. They basically, and the solicitor was definitely saying she should go, but then somehow capitulated. But isn't there something higher than either of them posturing whether or not it is strategically to their advantage or not about a juror's importance to be qualified?
Mr. Bryant could have waived his right to all of those. He has a right to waive 12. He can waive any objections to 1. Mr. Bryant saw that juror in court, saw her ability to convey with the judge, and he wanted her on the jury. And there was good reason that he wanted that person on the jury, because one thing that's been overlooked, and I see my time has run out.
Please follow what you said. Is a good reason why go ahead.
One reason that was overlooked by the district court was that this particular juror during voir dire stated she had a family member who was serving prison time for killing somebody. So right out of the gate, she's going to be inclined to support his position. She's going to be inclined to look at the family members of Mr. Bryant that came in and testified and empathize with where they're coming from. So at the end of the day, Mr. Bryant had the right to go forward with this juror, and he exercised that right. And everybody else agreed. At the end of the day, although they noted some concerns, she was qualified. I see my time has expired.
At this point, is any judge who has not asked a question would like to ask a question now? Hearing none? All right. Thank you very much, Mr. Roth.
Yes, sir.
Ms. Van?
Morning. May it please the court. I'm Lindsay Van, representing James Bryant in this capital habeas case. The state PCR court denied Bryant's fair trial claim based on unreasonable findings of fact directly contrary to or against the weight of the evidence in the state post-conviction record. The PCR court's findings that juror 342 heard all the guilt-phase testimony, was able to compensate for her hearing deficiencies, and heard all material evidence were unreasonable. The state court record is replete with evidence, including the juror's own admission that she missed testimony at both phases of the trial. Throughout the trial, the judge and the solicitor repeatedly recognized that the juror was missing portions of the testimony. She could not hear the judge when the judge was speaking directly to her, and that the lip reading and hand signal accommodations were simply not working. Contrary to the state court findings, the record demonstrates juror 342 was not able to carry out her duties as a juror because she could not hear or understand the evidence or the law and could not participate fully in the deliberations. The jury's death verdict on the basis of this juror's vote violated.
Ms. Van, Mr. Ross says that Mr. Bryant did not meet his burden at the PCR hearing. What's your response to that?
That is simply not true. At the PCR hearing, he called the juror's husband, who was able to testify about her hearing difficulties that dated back to 1984, well in advance of the trial of this case, and provided some explanation for why she would not be forthcoming about her hearing incompetencies at the trial. He said that she became furious when people would suggest that she needed help with her hearing. And as you mentioned, they presented an affidavit from her doctor who said that he found her to be deaf and that she should not have served on the trial without appropriate accommodations. But I think really the state trial record provides the best evidence of this juror's hearing incompetencies. Throughout the entire trial, the judge and the solicitor are going back and forth with their concerns over
let me ask the question. He chose not to call the actual juror at the hearing. Was that a strategic decision, or was it something that the law brought out under South Carolina law?
Well, South Carolina has Rule 606, much like the federal rule. There's not a direct case on this point under South Carolina law, but the U.S. Supreme Court in the Turner case found that a juror's testimony about incompetencies like this are not appropriate under Rule 606. And so I think there would have been an objection to her testifying about her abilities at the trial. But even if she did testify, she would not be able to clearly, as Judge Thacker pointed out, she heard what she heard, and that's what the trial judge said throughout the course of the trial. The solicitor said there's no way for her to tell us what she's heard and what she's not heard, especially after the passage of time between the trial and the PCR hearing.
So do we confront a factual question here? Typically in many cases where we're dealing with the facts, we look to the facts in terms of whether there's clear error or some lesser standard, and then in terms of sufficiency for legal on a legal basis. But here the question is whether there were material facts, and the court did make a determination that there was not a sufficient showing. So what are we reviewing? Are we reviewing the facts? Or are we reviewing the sufficiency of the showing, which then may lead into some of the earlier questions as to how much is enough? Otherwise, we're dealing with a factual question, and the burden being on the defendant here, we may not even get to the sufficiency.
Well, the question before this court is whether the state court, the PCR court factual findings were unreasonable under 2254D. Those facts are factual findings. There were only 4 of them that the juror testified she heard all the guilt-based testimony, which she...
Well, I'm just asking in that regard, does the question of sufficiency come into play in determining unreasonableness?
Are you speaking directly to the finding that there wasn't a sufficient showing that she missed material evidence?
Beyond it, what she actually found in terms of that, but I'm thinking in terms of if we're looking at a witness who, it appears as though there's some indication she says, I missed some evidence. We don't know what it is. The burden is on the defendant to say what it is. So we don't know, and I don't know how you would find out. You'd have to go through the whole trial transcript and probably say, did you get that? Did you get this? I just can't even conceive how it's done. But my question goes to, in determining whether it's unreasonable, do we look to determine a question of sufficiency? And if we do, who has that burden of showing the sufficiency of it?
Well, I think to step back, I don't think there's no requirement under the Supreme Court law that there be a showing of exactly what the juror missed. As Judge Gregory pointed out, there can be a juror that is just incompetent to serve, and the requirement under the Supreme Court law is that the juror be able to render a decision based on the evidence at trial. And looking at the record as a whole, it's clear that she is unable to hear even when the judge is speaking directly to her and raising her voice. Certainly a hearing impaired juror could sit on the trial, but they have to have some sort of accommodation to allow them to hear or understand the evidence.
Counsel, I'm still puzzled as to the absence of the juror in the PCR hearing, because I think that the juror herself would have been a highly relevant evidence. And you say there was a barrier under South Carolina law to poking into jury deliberations, but did the PCR counsel for the defendant try to get the evidence or the juror's testimony in so that the PCR court could have some sense of what the state of her hearing was? Was there an attempt on the part of PCR counsel to introduce her as evidence? Because this is not necessarily plumbing internal jury deliberations. It's just trying to gauge what the state of her hearing might be. But I wonder whether there was any effort made to produce her testimony.
No, the only thing that is in the record is that she was there, but there was not an attempt by PCR counsel to submit her as a witness or her testimony. Instead, PCR counsel, I think reasonably and in a showing of what she, what her hearing capabilities were, presented her husband who had experience with her hearing.
But wouldn't that testimony have been highly relevant, to say the least?
No, I don't think so. I think that the juror would not have been able, as Judge Wynn pointed out, would not have been able to go through the transcript and kind of figure out what she heard or what maybe she didn't remember after the passage of time before the PCR hearing. I just don't know how a juror can tell you what she's heard versus what she hasn't heard. As the trial judge pointed out, she's heard what she's heard and she doesn't know what she's missing. There's no way for her to provide that testimony.
But let me ask you something. It seems to me that if she's called to testify and she's questioned, just the very fact of questioning and answering questions would be indicative of her ability to hear. And as you know, this record contains all that Judge Thacker pointed out and Judge Harris. It has those comments, but what is not spoken is there were numerous times where the judge and juror 342 communicated extensively, 8, 10, 12 questions, and they're going back and forth, and she's answering the questions and the judge is asking questions, and there was no indication in the record that any of those conversations caused her difficulty. And they're quoted in the panel opinion. But I was just counting one of them with 9 questions back and forth. Another one was 8 questions back and forth. She answered them all. So the question is, if she's in the courtroom, she was obviously called to the courtroom, probably. Her husband, I suppose, could have come alone, but and she takes the stand and is able to answer questions, that would have been indicative of something, or if she were not able to answer questions. But that's left to be a mystery at this point. I mean, we don't have to go to the substance. It would be helpful, of course, to inquire about the materiality or the importance of certain types of testimony. I'm not sure she would be able to recollect specific testimony, but I would think she would certainly be able to recall facts that may have been presented at trial, major facts. But that's a big shortfall. And here you have every single judge and participant saying, in the end, it was probably okay. There are problems there. But it comes down to this factual question on the record, which each judge can ask about a particular exchange with the judge, and it goes one way or the other. But we're a federal court looking at a state proceeding. And so the question, I think, is appropriate as the burden's pretty heavy, isn't it, in this circumstance?
I think there are a couple of questions there, but to the question of could you bring her in to just have her interact with the judge and see how that goes at PCR?
Well, I wouldn't say that would be the primary goal, but that would certainly be indicative, wouldn't it?
Well, that is what happened at trial, and I disagree with the reading of the record that she was able to carry on a conversation with the judge. Many of those questions are the judge following up with her because she's clearly not understanding.
Well, without taking up all your time and the court's time, I'm looking at page 136, and it starts with a question from the judge, and juror says, yes, ma'am. The judge asks another question. He says, just one point. I thought I missed a little, but I didn't. I thought about it. The judge says, you're missing anything? No, ma'am. Keeps going. No, ma'am. I may have missed a little, but just a little bit. Okay, all right. Did you miss some in the phase? Yes, ma'am. Do you think? Yes, ma'am. Did you find in that same situation? She goes down. This dialogue is going on. And she's not saying, I can't hear you, judge. And there's another a dialogue of similar length on the same page in the second column. I'm not saying that's we have to make a finding on that. What I'm suggesting is the record provides evidence to the contrary of those questions that have been placed before the court earlier. And it seems to me that the task in this whole setup is to let the state make a call on that. And unless the state was totally off the wall, it seems to me that our role is quite reduced in this kind of context, isn't it?
Well, yes, there has to be deference to the state court, but the state court's findings are simply unreasonable on this point. And the colloquy that you just shared, she's admitting that she's missed some of the testimony at the.
She says she may have missed some, and she turned away, and she may have missed some. And then she said, did you hear? And then she's asked about the guilt phase. Oh, I got it all. I may have missed something here. I mean, the fact is, she said, I turned away once. These are all incidental, but my point isn't the substance. My point is she's engaging in an ongoing conversation with the judge without difficulty. She didn't say, I didn't hear you, ma'am. Could you repeat that, ma'am? She's answering the questions, and she's responding substantively to the question that the judge is asking. Now, how do we account for that testimony? I mean, that record portions, and it's not just isolated. It's again and again and again, every time the judge raises the point. As a matter of fact, she passed 2 of the tests. The judge asked her questions. She missed the one on the blue dress. She had a dark blue dress with polka dots. And she didn't. So but quite apart from it, we don't need to argue the evidence because the evidence is clearly mixed. There's no question about it. My only point is the PCR court had her in the courtroom. They could have called her. We could have found out a little bit more about her, and it wasn't done. And so the question is, who carries the risk of failing to carry the burden of showing that it was prejudicial, it was material?
Well, certainly at a PCR hearing, the petitioner has the burden, but I submit that has been satisfied here. The trial.
Ms. Vann, wasn't there evidence at the PCR hearing as to why she would not have admitted that she could not hear?
Yes, Judge Thacker. The husband said that she was very sensitive about her hearing problems and would get angry when someone would suggest that she needed assistance with her hearing. And we see that play out time and again at the trial. Eventually, she admits that she missed some of the testimony, but never during the course of the trial did she take advantage of the accommodation of raising her hand.
So let me ask you. I think Judge Niemeyer has rightly pointed out that probably the biggest hurdle here is whether you satisfied this burden, and the question of whether the PCR or the defendant could have called this juror seems to be central. And there is Rule 606B, and then there's the Tanner decision that seems to indicate that because this is an internal matter, you couldn't call this juror. And yet, intuitively, she's the one that it would seem to me would have some pretty strong indication of what she heard and didn't hear. And I don't know if I've seen that question before come up as to, and that's the only part of this case that's beginning to really trouble me a bit, and that is not calling her. And was it a matter of choice, strategic choice by the counsel, or was it something that Rule 606B read under the understanding of Tanner, the Supreme Court case, would say you can't call that witness? And, you know, because neither you called, nor the PCR court called, nor the solicitor in the case, and this is a death penalty case. And while we want to hang our hats on procedural rules and things, I'm beginning to have a little trouble in spirit in terms of a death penalty case, and you're asking this question, and nobody calls this witness. And the only conclusion I'm coming to is you must not have been able to call her, because I wouldn't see why you wouldn't call her. Somebody would call this woman up at this hearing. And I think Judge Niemeyer is right, that's critical that she wasn't called. I'm interested in why was she not called? Was it strategic, or is it something, and even though the burden's on you, it seems to me in a fairness inquiry in a death penalty case, somebody would want to know, was this woman able to hear? It's not, I don't think the court can just sit on his hands and say, she's okay. But Judge Niemeyer has pointed to testimony in the record, but I'm talking about the PCR court in dealing with it. It just seems to me she's one of those witnesses you would want to hear from. Well, how does that play out? And I think that's just critical in this case.
I think the Tanner case is very clear on this point, that where juror impairment is a question, that juror testimony is not admissible under 606B, that it is internal to the jury deliberations.
So let me ask you this. If that's so, then how is it you were able to consider that testimony on page 136 where she's talking? I mean, I know that's at the trial, but it's kind of the same thing. She's talking about internal affairs. I don't understand Tanner, and I'm not sure if this is a matter. I haven't seen it. I don't know if any other cases are on it. Or do you know the other cases on it? Or is this a matter of first impression for us dealing with whether, and I guess South Carolina law may impact it to some degree, but we're talking about the federal rule 606B in the Tanner case.
Tanner actually speaks directly to this. It says that after the verdict is rendered, it's not appropriate for the jurors to testify about juror impairment. But during the course of the trial, there are a number of things that are supposed to ferret out juror impairment, including the juror's own testimony or the trial judge's observations. And that gets back to the trial.
Let me ask you on that. If we made a decision that, yes, you could call this witness, this juror, and send it back just for a consideration of her testimony, is that permissible in lieu of a full resentencing?
I'm not sure if it would be appropriate to send it back, and I don't think it's necessary. The trial record provides sufficient information to demonstrate that the PCR court's findings were unreasonable.
Okay, let me make sure you understand what I'm asking. On the one hand, I'm saying, do you maintain that the law did not allow this witness to be called?
That is not decided under South Carolina law. There's no.
I understand that. It may not be under South Carolina law, but I'm dealing with Tanner and I'm dealing with 606B. Was that the basis for not calling this witness?
I don't know. The record is silent on why they did not call the witness. But in addition to.
This is Judge King. I thought you said earlier that she wasn't called because of this 606 privilege.
No, I'm sorry if I misspoke. I meant to say that was a possible reason that she was not called. The record is silent.
A possible reason that she didn't get called.
Does South Carolina have the same rule?
Yes, it is the same rule.
Same rule? Has South Carolina construed that rule?
It has construed that rule, but not in the circumstance of an impaired juror. The case that I think is closest on point is the Tanner case addressing the federal rule.
No, I'm talking about South Carolina law.
No, Your Honor. The South Carolina Supreme Court has not addressed in this particular situation. Judge Quattlebaum, I'm sorry if I cut you off.
No, thank you. I appreciate you answering that. I mean, and I think your clarification is the point I was getting at. I mean, we've, in the course of this oral argument, talked about perhaps the juror wasn't called because of legal impediments. And there's also the possibility that there may be a strategic reason. But the fact of the matter is, there's nothing in the record that tells us for sure, and there's certainly nothing in the record that suggests Mr. Bryant attempted to call her and was precluded because of either Tanner or Rule 606. Isn't that correct?
That is correct. Yes, Your Honor.
Thank you.
Ms. Van, could
what's your
you
position on-
speak? Yeah. Go ahead, Judge King.
I wanted to, if you were going to follow up on that, Judge Thacker, you go ahead. But I was going to try to get her position on this invited error doctrine.
Yes, it's our position that that is a procedural bar that was not invoked by the state court. The state court addressed this claim on the merits, and that's sufficient to raise this as a claim that is available for review under 2254D by this court. And the state never raised invited error as a procedural bar, not before the state court, not before the district court, not before the panel of this court. And as
it was first raised, invited error was first raised in connection with the in-bank proceedings, correct?
Yes, Your Honor.
And it was raised by our court rather than any lawyers.
Yes, that's correct. It was not raised by any of the parties. And so it simply should not apply to bar relief, especially in a capital case where the defendant's right to a fair trial is at issue, and where the evidence shows that there was an impaired juror who was seated on the trial that made the determination of the death verdict.
Okay, can you speak to the district court's alternative ruling about ineffective assistance of the defense counsel and not objecting to having this impaired juror continue on the trial?
Sure. We also raised an ineffective assistance of counsel claim that it was not a reasonable strategic decision by trial counsel to keep her on the jury. It simply, if they wanted to keep her in the hope that she would be a holdout, she wasn't hearing the evidence. And so for her to be able, to rely on her to be the person to vote for a life sentence was simply unreasonable. And looking at the reasons that the state PCR court relied on was that he didn't like the—
Counsel, let me interrupt you. Why do you say it was unreasonable? Which sort of goes back to the invited error. I mean, counsel was well aware of, for all the reasons that have been discussed today, of hearing difficulties for this juror. The defendant was certainly aware of it. The court asked him about it on the record, and they thought this was a good juror for them. Why wasn't that decision reasonable for them to make?
It was unreasonable because the trial counsel really was acting out of kind of willful blindness to the evidence that was before him and all of the interactions between the juror and the judge.
Why do you say it was willful blindness? I mean, they had lots of dialogue back and forth with the solicitor and the trial judge about this. And as I just mentioned, they had a consultation with the defendant. The defendant answered on the record. They knew exactly what their potential problem was, but they thought that was a good thing for them. Why wasn't that reasonable?
Well, the trial counsel is going through and saying, well, maybe she thought the dress was black, not blue. And then she comes back and answers that specific question saying, no, I knew I was wearing blue. I just simply didn't hear. And then the judge makes the finding on the record that she just flat out did not hear.
No, but I don't think you're answering, I don't think you're answering Judge Agee's point, which I thought was a very good one. That all along during these proceedings, I suppose initially at voir dire and jury selection, but then during the course of the trial, as Judge Agee points out, any hearing impediment, if such there was going to be evident. And yet, was there any attempt made to either strike the juror as part of a peremptory or to have a mistrial declared or whatever? Because the danger here is that, as Judge Agee points out, you think somebody's going to be good for your side, and strategically what you're doing is you're foregoing any attempt to excuse or disqualify the juror. And if the verdict turns out adversely to you, you've got in your hip pocket a claim for collateral review to bring up before us here? And why isn't this just a classic case of sandbagging? To let the trial go along with the same problem that's right before us here, make no attempt to disqualify the juror, to strike the juror, to declare mistrial or anything. And then all of a sudden, whoops, the verdict wasn't what we wanted. We've got this impaired hearing juror claim. It just looks like, as I say, I'll repeat myself, but it looks like sandbagging to me. In addition to all the problems with the standard of review, we're seeming to whipsaw state judges and state trial judges with this kind of hearing, with a ruling that vindicates this claim in a collateral context. That's my problem, is it just seems to me to lend itself to manipulating the system where you go through an entire trial without raising a problem, and then all of a sudden, oh, we've got this terrible injustice that we're going to raise on collateral review. And I think that's what Judge Agee is holding in on, and I think he's absolutely right about that. And I'll give you another chance to answer his question, but I don't think you did.
Well, I think that assumes that the only person who's responsible for protecting the constitutional right to a fair trial is the defense attorney, and that is not the case. The Tanner case is clear that the trial judge has a responsibility to be observing and to protect the defendant's right to a fair trial and to a competent jury that can render a verdict based on the evidence. And instead, we have the trial judge basically abdicating her role even after finding that the juror was not able to hear even under ideal circumstances when the trial itself has been much less than ideal.
Ms. Van, can I follow up on that? You said abdicating their role, but you know, they did go back and forth on this for a while, and one of the points that was made, and I think both lawyers may have made it, is that, you know, we don't demand perfection from a juror, and they made the point that throughout the course of a hearing, particularly a long trial, it's inevitable that a juror is going to miss something along the way. And they sort of analogize the situation with this juror to that. For a variety of reasons, a juror is simply not going to catch everything. And as Judge Agee pointed out and Judge Wilkinson pointed out, the defense lawyer in this case was adamant that the juror may not be perfect. There may be some issues here, but we want to keep her for their own strategic reasons. And I guess it gets back to the question that Judge Agee asked, and in that context, in the context of the fact that we don't demand and can't expect perfection, why isn't that a reasonable strategy?
Well, I agree that we can't demand perfection, but this is much more than just the average distraction by, you know, any juror. It's clear in the record that even when she's trying to listen to the judge who's speaking directly to her, she says she's trying to read the judge's lips, and she simply did not hear the request to stand if she was wearing blue. I see that my time's up.
You may finish answering Judge Diaz's question.
Thank you, Your Honor. Even under the ideal circumstances where the judge is speaking up and she's looking directly at the juror, there's no back and forth of the chaos of, you know, how a trial actually goes on, she's still not able to hear that question. And that demonstrates that even when she's trying to pay as much attention as she can, she simply cannot do it. And so that makes her, you know, missing much more than what the average juror would miss just in lapses of attention.
Is any other judge who has not asked a question would like to ask one now? Not?
I think there's rebuttal, isn't there?
Yeah, there will be. Yes. Thank you, Ms. Van.
Thank you, Your Honor.
Mr. Ross, you have some time reserved.
Thank you, Your Honor. If I could please talk about the ineffective assistance of counsel claim that was raised. And I think the district court's fundamental failing is that it looked at counsel's performance through the lens of hindsight. Strickland is clear that you don't do that. You have to look at counsel's performance based on the situation he faced there in the trenches. And this trial attorney essentially had three options at his disposal. Best case scenario is he wins his case that day. He has got a juror that he believes is favorable to his position, and he makes his case and he gets the sentence he wants. Middle case scenario is
there evidence of what you're saying, or you're just speculating?
I'm sorry, Your Honor?
You said that he had that was favorable to him, so he was interested in keeping her on. Is there evidence to support what you're saying in this record, or are you speculating?
The evidence that supports that is during voir dire, she indicated that she had a relative that was serving prison time. The defense offered tons of family members. She's going to be inclined to view the evidence from their perspective, to sympathize with those family members. So there is evidence in the record showing that this, not only did this attorney want that juror, but there's evidence to support that attorney's.
Mr. Ross.
Did the lawyer ever testify?
Yes, Your Honor, he did testify.
Pardon?
He did testify at PCR. And
did he say what you said?
He, in addition,
no,
he did not reference that particular fact. For that particular fact, I don't think you would need trial counsel to explain the significance of a juror.
What did he say when he testified?
He said his primary concern was he didn't particularly care for the alternate. And that shows that he has, at that point in time, he's got a duty to avoid the worst case scenario. And the worst case scenario from his position is to replace a favorable juror with an unfavorable juror, with that alternate. A mistrial is not assured. A mistrial in South Carolina and in federal courts as well is an extreme remedy.
Did he say that he thought that the judge was going to remove her based on the conversations with the solicitor, who clearly was concerned about her not being able to hear? Did he say that at one point in his testimony?
He speculated that he thought that.
So yes.
There was never, he also testified that there was never a formal request, that he didn't request
and
that.
But he did say that. Did he also say that that juror never should have been on the jury because she couldn't hear? He fell on the sword, basically.
What he testified to was he didn't realize the impairment until after he read the transcript. That's at 1074 and 1083. So that tends to suggest that what he's reading in the transcript appears worse, and what he saw appears worse than what the prosecutor, the judge, the other defense attorney, and Mr. Bryant. That just reinforces.
So, Mr. Ross, can I?
Mr. Ross,
I'm sorry. Go ahead, Judge Quattlebaum. Sorry.
So, I have a question about what we can consider in this ineffective assistance issue. You talked about the information from voir dire that was given, and if that is not articulated by defense counsel as a witness, can we consider that?
You can, because Strickland is an objective standard. Whatever subjective ideas or whatever subjective considerations this particular trial attorney had, while relevant, are not dispositive. So if Strickland is an objective standard, then you look at it objectively. And from an objective perspective, having a juror who's got a family member sitting in prison for killing somebody is probably somebody you want as a murder case.
Mr. Ross, just to follow up on some questions that were asked, and I don't know that you've done this intentionally, but wasn't there, and I'm going to ask you this question as to whether or not this was a reasonable basis for keeping the juror. I mean, the fact of the matter is that the defendant in this case was African-American. There was some evidence with respect to whether, or some indication that the officer in this case may have engaged in racial profiling. And I guess that begs the question of whether or not the lawyer in this case would have acted reasonably in thinking, particularly since there didn't appear to be many, if any, African-American members of the jury. That may have been one other, whether the injection of race in this case was an appropriate consideration for the lawyer to consider in deciding whether or not to keep the juror.
I think there's a distinction between considering race in a peremptory strike and considering race in the jurors that you already have called. You're correct. Mr. Bryant believed he'd been racially profiled in that stop. And trial counsel at PCR testified that one of his strategies was to attempt to elicit an explanation for why Mr. Bryant murdered Corporal Lyon. And one reason given to him by his client was that he thought he was racially profiled. And this trial counsel had committed to that strategy during the guilt phase. So before the solicitor moved to have her withdrawn, the trial counsel is cross-examining the eyewitnesses that are saying he ran the stop sign pretty heavily. And because he's already committed to that strategy, he's quite clear in his testimony, and I'd like to bring it to the court's attention at ECF 69-12, page 66, and then 75 through 78. That's, as well as 1067 and 68 of the joint appendix. Trial counsel is quite clear that he doesn't understand, based on his perspective, his life experience, what it's like to be African American and feel you got stopped by the police. But it's reasonable that somebody that has lived that experience may be more sympathetic to his case. So this isn't a situation where there's pernicious, race is injected perniciously. He's simply trying to get a fair cross-section of the community on his jury panel so that his mitigating grounds can get a fair hearing. So I don't think that's improper, and I would point the court's attention to the Weatherwax case, where the Second Circuit made that distinction between considering race in a peremptory challenge versus understanding the jury you have and trying to keep a favorable demographic on your jury panel, because trial attorneys have to base their strategies on probability. It's not unreasonable to assume that this juror is likely more probable to believe that.
Counsel, it's Judge Harris. So the district court agreed with you on that point, right? The district court is very clear in finding ineffective assistance. I'm not saying it was impermissible to consider race, to have a strategy that took that into account. So you've got no quarrel with the district court on that. You won that point. The district court went on to say, notwithstanding that, given the nature of a mitigation case where the whole thing turns on how a juror is going to respond to this very subjective evidence about the value of a human life, you just can't decide to have a juror who can't hear your mitigation case. So notwithstanding all of the what the district court viewed as sort of legitimate strategic considerations, the district court concluded, look, this is just not a reasonable strategic decision, particularly in the context of a mitigation case where just like you just don't know which detail, like which fact is going to resonate emotionally with the juror to encourage that juror to vote for life. You just can't put on a juror who you know is not going to hear a lot of what your witnesses are saying. So can you address that part of the district court's holding?
Well, he didn't know that she couldn't hear.
Okay. So
wasn't aware.
So this is basically just I don't mean to, but so this is just, I'm sort of it's the same merits argument as to both as to ineffective assistance as to due process. You would just say, look, she could hear enough.
I would say there is a subtle distinction that Strickland makes clear to base the actions on what he thought at the time. And what he thought at the time was that this juror's hearing impairment wasn't a problem. It certainly wasn't a problem to remove a juror that's going to be favorable to him. Again, he's testifying that he only understood the extent of the impairment after he read the transcript, which just reinforces the initial point.
Mr. Ross, can I, oh, sorry, Judge Motz, go ahead.
Can I ask you a follow-up question to that? If, I know this isn't what you were saying, but if it was conceded that this juror could not hear, would it be ineffective assistance of counsel to put him on the jury?
Number one, again, we will not make that concession that the juror.
I understand. Did you hear the first part of my question? I understand you're not making the concession. You're not making the concession. If this juror could not hear, would defendant's counsel have committed ineffective assistance by agreeing for him to be on the jury?
You know,
What?
I think you would have to know how much she could hear. Are you saying completely deaf?
Well, let's start with completely deaf.
Well, I think there's a wide range.
Ineffective assistance. Is
there
that
is
what you're playing?
I'm sorry, Your Honor.
I don't think this is a hard question. If the juror is deaf, is the defendant's lawyer guilty of ineffective assistance by permitting him to be on the jury, but not asking to have him struck?
I think trial counsel would have wide latitude. Strickland, I don't think, no, Your Honor. I do not.
Well, now I understand your position. Great.
Because of Strickland's wide range of what's reasonable under Strickland.
Right, and having a deaf juror on is reasonable in a case in which there is testimony, particularly in the mitigation case, which no one says that there was a lock there. Everybody agrees that there was mitigation evidence, but it would still be reasonable to have somebody deaf who might pick out one particular part of the mitigation evidence, as my colleague said, and find it significant. But that wouldn't be ineffective assistance of counsel to let that deaf person sit on the jury.
Not every deaf person is the same. Some can read lips. Some are going to be inclined to support your position.
No, I do understand that, but I'm hypothesizing. I know you don't think this is the case, that the juror in my question is deaf. And I'm asking you if the defendant's lawyer would be guilty of ineffective assistance if he permitted a deaf juror to sit on the sentencing part of the case.
No, because that is a
I'm sorry, I still didn't hear you. No,
and that is because that is a black and white question. Practicing law involves judgment that is not black and white.
All right, are there further questions? If not, thank you, counsel. And Ms. Van, I note that you're court appointed, and I want to give you a special thanks on behalf of the court. We appreciate lawyers like yourself who take these cases and help us on these very difficult cases. We appreciate it very much. And Mr. Ross, we thank you for ably representing the Palmetto State.
Thank you.
You're welcome. We can't come down and greet you like we'd like to, but nonetheless, that we really appreciate you being here. We wish you to be safe and stay well. And thank you so much, counsel.
Thank you, you too.
All right. Bye.
Thank you, Your Honor.
Take care. Bye-bye.
Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Ms. Metcalf?
Good morning. May it please the court. My name is Hannah Rogers Metcalf, and I have the privilege to appear before this court today on behalf of the appellant, Precious Freeman. Precious Freeman was denied her Sixth Amendment right to effective assistance of counsel at sentencing. Freeman's retained counsel, ignorance of the law, rules, procedure, and the facts resulted in errors so egregious that her counsel was not functioning as the counsel guaranteed by the Sixth Amendment. And as a result of this woefully ineffective representation, Freeman's sentence was significantly longer than it should have been and substantively unreasonable.
Ms. Metcalf, the panel held that he was ineffective. He provided ineffective assistance to counsel, and we did that on direct appeal. There is some opposition from members of the court about that process. Can you give us your thoughts about, can we do that? Should we do that in this case?
Certainly, Judge Floyd. This is an uncommon case. It is rare that the court considers ineffective assistance on direct appeal. But it is not completely unheard of. In fact, the Supreme Court in the Massaro case in 2003, Justice Kennedy wrote for the court, and he said specifically, we do not hold that ineffective assistance of counsel claims must be reserved for collateral review. There may be cases in which trial counsel's ineffectiveness is so apparent from the record that appellate counsel will consider it advisable to raise the issue on direct appeal. There may be instances, too, when obvious deficiencies in representation will be addressed by an appellate court sua sponte, which is what happened in this case. It is a prudential rule that this court follows, and this court has never said that it cannot be considered on direct appeal. It's a prudential rule.
Let me ask you, there's some cases that are obvious. I think we had one a while back where a conflict of interest was well established and the attorney simply could not represent the defendant. That appears conclusively in the trial, and we can rule on that. This case turns on what the lawyer knew, what his strategic decision was, what he told the defendant, and what the defendant said, and whether they were thought that maybe their objections wouldn't yield anything beneficial, and trying to seek favor with a court of some kind. We have none of that evidence, and under a 2255, we would get that evidence. And as you know, the word conclusive is the standard, and it's very hard without that evidence to rule conclusively that he provided ineffective assistance.
Judge Neuer, you're correct as to the standard, and you're correct that in Glover in August, this court found that a conflict of interest was apparent on the record. This year as well, this court in the Sturdivant decision found conclusively on the record where counsel had withdrawn meritorious.
Well, I raise that only because I'm trying to address the Supreme Court's language, which didn't bar it. I think we and the Supreme Court much favor the relationship between attorney and client be examined on 2255. We have the very unseemly problem of requiring an attorney to abandon his client in the very case in which he's representing the client. And to get any testimony from it, we just couldn't do that. So my question really comes at, in the circumstances of this case where we clearly are missing evidence, I would love to hear what the attorney has to say for himself, and I'd love to hear what the attorney told the client and what the client understood. And we have none of that evidence. And to say that, to eliminate the possibility of strategy without any evidence one way or the other, it's hard to say it's conclusive. This is the type of case that would benefit from the development of a record. And it's not that the defendant will lose this opportunity. It's just that it'll be transferred to a different procedural context where this can be better examined. Whereas on the rare cases where we can find representation conclusive, it's a clear black and white fact. And my example of a conflict of interest is one example. I happen to be on a case maybe 10 or 15 years ago, 20 years ago, where that was the example we focused on. And we said, there's nothing more to, I mean, if the person has a real conflict of interest, we can address it during the trial. But when you're talking about decisions, whether to waive, how to proceed, discussions between attorney and client, sure, this attorney manifested a lot of problems. There's no question. You've got a good record on that. But it troubles me that we don't have the important evidence that would eliminate any strategic issue in this case. And 2255 wouldn't deny this client anything, but it would give us a fuller record. I think that's the question that Judge Floyd is really raising, but it's my number one question with respect to this case, because I think we have to be able to conclude these facts conclusively. And I think in the context of what we have, that's a hard standard. Oh, it's not only hard, it's almost impossible to meet.
I think in this case, we do have the facts that you need, and we do have the conclusive evidence, and we don't need the testimony. In the regular course, normal cases, you're correct that we do need that testimony from counsel. But here, we have the testimony from counsel because he states on the record 3 separate times that he doesn't understand the law. You can't get any clearer. We don't need to know what he told his client because he told the court. He says, these objections aren't going to change anything in essence, what the charges are. None of these.
They might not. They might not. He may have made an assessment. I mean, what you say could be right, and it might even be more likely than not that he's all messed up. But the 3 objections he's making is drug weight. And if you really take relevant conduct, the drug weight going back 10 years or whatever it is, she got off very easy on drug weight. Obstruction of justice when she fled after the trial and remained away as a fugitive. And what was the third one?
The acceptance of responsibility.
Acceptance of responsibility, yeah. Now, the question is, if he says to her, I've examined these things and I've concluded we're not going to win, and I'd rather not get the judge pushed back against the wall, I'd like to ask for mercy. He may be wrong, but if he said that or he explained that, it'd be a different picture, wouldn't it?
Well, that's not what he said on the record. He said on the record, they don't make a difference.
Well, they may not. He may have made an assessment.
Yes, Judge Quattlebaum? Judge Quattlebaum, I can't hear you.
I'm sorry about that. I think the most troubling thing he says is on JA 108, where he says none of the objections reduce the number that is relevant to the court. And in isolation, I think that would be, very difficult. But shouldn't we read that in conjunction with what he said on the page before, when he is really talking about his objections, even if they're successful, aren't going to change much? And even with respect to the drug weight, if, for example, you went down to the 1 prescription per day, you still have the 180 to 210 months. I mean, I'm not prejudging that you wouldn't win on collateral review at all, but it seems like you need to look at the testimony as a whole, and there's at least some possibility of reading that the way Judge Niemeyer has described what he was doing. And I mean, do you disagree that that can be read that way at all?
I do disagree that it can be read that way. He states it repeatedly. The district court even leans over at one point and says, listen to my question. and gives him an opportunity to explain withdrawing these objections, and he doesn't take the suggestion. He says it repeatedly, and he demonstrates throughout the record that he doesn't understand what he's doing. He files a civil motion afterwards trying to reassert these objections. He filed a motion for bridge court for which his client wasn't eligible. And he states on page 107 of the JA, Judge Quattlebaum, which I think what you're referring to, he says, objections are not going to change in essence what the charges are. Drug court is more pertinent than objections over what might be considered minimal, although these were not minimal objections for Ms. Freeman, even if found to be appropriate or the arguments being valid. He hasn't done his research. He's ignorant as to the law, and he's stating his ignorance on the record. It couldn't get much more clearer than this. And from my perspective, from our opinion, Ms. Freeman contends that this falls under this court's precedent in Fisher. This was an opinion written by Judge Butzner, who the en banc courtroom is named after, where he points to a situation in the record where counsel said, and it happened to be transcribed, I'm not really prepared. I only had an hour. This is very similar.
Do you have the responsibility to establish also the second Strickland prong at this point, prejudice?
Well, yes, Your Honor, we have to establish prejudice. But prejudice.
So you would have to establish incompetent or inadequate representation, number one, and prejudice, number two, conclusively in this context of this trial.
Well, prejudice, Your Honor, as you well know.
No, I'm asking you on the burden. I'm not asking you what you show. You'd have to carry that burden.
That's exactly right. That's exactly right, isn't it, Ms. Metcalf?
That's correct, Your Honor.
Well, you need to answer him straight. Yes.
Yes, Your Honor, that we do have the burden of establishing both prongs of Strickland on direct appeal. And here she is prejudiced. There's significant likelihood that the outcome would have been different had her counsel understood the guidelines.
So counsel is, just so I understand what is issue in the prejudice part of that, she would have to convince us that she would have prevailed on her objections, and that even if she did, that the judge would not have sentenced her to the same sentence. Is that right?
It's not that she would have absolutely prevailed, but that there's a strong likelihood that she would have prevailed.
Fair enough.
And we contend.
Why do you say strong likelihood? I thought the standard now is conclusive.
I'm sorry, I couldn't hear the last part of your question.
I thought the standard for finding ineffective assistance of counsel during the course of a trial, the standard is conclusive. Don't we have to show she would have been prejudiced? She would have to show, not more likely or not possibly.
We have to.
We would have to show that they missed something that the court would clearly have seized on. The court said just to the contrary. I'll address these, and the government had its witnesses.
The Supreme Court has said that she must show that there is a reasonable probability that but for counsel's unprofessional errors, the result of proceedings would have been different.
Ms. Metcalf, can I?
Go ahead.
Sorry, go ahead. Go ahead, Judge Niemeyer. Go ahead.
No, I was just going to, I'm trying to recognize the difference between a 2255, where I think you can make your case and you have a lot better standards favoring you, than during the course of a trial where all these open questions would have to be resolved, and we don't have evidence on them. We have some evidence, but we don't have a bunch of evidence.
Ms. Metcalf, can I ask you about sort of the burden here, whatever that burden is? And the question is, do we assess each of these potential sentencing enhancement objections separately? And if so, you know, my read of the record suggests that the strongest one of these for your client would have been the drug weight, based on the sort of paucity of evidence in the record. A much lesser strength, I think, evidentiary strength with respect to the other two, the obstruction and the acceptance of responsibility, in part because of, someone mentioned this, I forget who it was, that your client did flee the jurisdiction, and there's some evidence in the record that she may have engaged in further misconduct during that time that she was away. So I guess the question I have for you is if only one of those, let's say the drug weight evidence is the one that has merit and that reduces the guidelines, as I understand it, it's still, this sentence would still remain within that modified guidelines range. So why would we find prejudice on this record if in fact that's what we hold?
Your Honor, as I understand her drug weight objection, if she were to prevail on that objection, and I agree with your assessment of these objections, if she were to agree on the drug weight objection, her offense level would be reduced accordingly and could be reduced at least 2 levels, 2 offense levels. And while 210 months would be at the top of that range, the bottom of that range would be 168 months. And so that is a significant difference. I mean, that's a matter of, that's a long time for someone to spend behind bars. And so that would be a substantial difference for her. And we could then show that there was a reasonable probability that but for him withdrawing this meritorious objection, she would have had a different sentence. And that suffices, that meets the burden of the prejudice prong of the Strickland test.
And so how do we factor in the additional record indication that the judge in this case appeared to be bound and determined to sentence her to the sentence that he arrived at, notwithstanding whatever mistakes may have been made with respect to the enhancements?
Well, I'm gathering that Your Honor is referring to the standard, the harmless error standard under Savion Matute. But
right.
that standard states that it's harmless error for procedural sentencing errors made during a guideline calculation if the court, as here, says it would impose the same sentence, but only if the sentence is reasonable under the 3553A factors. And we would contend that the sentence wasn't reasonable in light of the error and in light of the other aspects of our brief where we contend the sentence is unreasonably high when considered against other similarly situated opioid defendants.
But you would be.
Go ahead, Judge.
I'll be real quick. But if you did that, Ms. Counsel, you'd be arguing, if you prevailed on the drug weight alone, you'd be arguing that a within guidelines range, albeit at the top, is unreasonable. Is that correct?
Well, I don't think so, Your Honor. The judge here said he was sentencing based on the guidelines that were presented to him. And let's be clear, he didn't make a determination of the guidelines because the objections were all withdrawn. So he didn't actually rule on anything. He accepted the guidelines that she conceded. It's not clear, he says he would have sentenced there regardless, but it's not clear if the guidelines had been calculated differently, if he had ruled on the objections, if he would have given her the same guideline sentence. Yes, Judge Harris.
Counsel, wait, something you just said triggered a question I have about what the judge said. You said he says he would have ruled the same way regardless. But in this context, where, as you point out, there is no challenge to the guidelines calculation, I'm struggling to figure out what regardless means. Like, regardless of what? Usually when we get this kind of that sounds normative. Usually when we get this kind of statement, I would have sentenced the same way, whether or not I am right about this particular guidelines argument that the parties are having in front of me. And I understand there are 2 different hypothetical guidelines ranges, and whichever of those 2 ranges I'm looking at, I'm sentencing the same way. I understand that. That is like a statement that has some content. When I look at this statement, this is just, there's nothing in front of me. I'm just here to say, literally whatever the guidelines are, I'm going with 260 months. The guidelines could be probation to 3 months, and I don't care. So I don't know how to, I'm having trouble just figuring out what meaning I should ascribe to this kind of a blanket, there's nothing in front of me, but whatever the guidelines are, I'm not changing my mind. This seems unusual to me, and I wonder if you could address that.
Well, Judge Harris, I would agree with you that it is unusual because the court didn't make a determination. There's not an allegation here of a procedural error. And this court and the Supreme Court have been very clear that these kind of blanket statements can't immunize an error. They can't immunize a sentence. And so it is unusual that the court made that statement because he didn't actually make a determination as to any of these objections. So it's not clear why that statement is there. And we would contend that it doesn't immunize the sentence.
Well, it would seem that that statement, if it did immunize anything, would be the judge's error and not the counsel's error. Here you've got, as you started out, you're pretty brazen in terms of how this counsel conducted himself at trial. But it is clear Judge Diaz pointed to the weight, and then there's the obstruction of justice enhancement, for which the guideline notes make it pretty clear that doesn't apply to a fleeing type person, someone who is in that type of an instance. So there is something there. I'm not saying it would be conclusively found, but I'm saying it's there. The problem that seems to be emanating, at least in terms of my thought process, is listening to Judge Niemeyer's questions in light of the other questions here on the conclusiveness. And when we're looking at Strickland prejudice, I don't think it's a more likely than not standard. It is really one that deals with a reasonable probability. And so, but our cases seem to at least indicate, talk about conclusively appear from the record that the defense counsel did not provide effective representation. But it doesn't seem to make any sense to say you must conclusively show reasonable probability of prejudice. So I think there's some tension there, at least in terms of how we analyze this from the inception. And if we're going back to the prejudice act, it's really the Strickland prejudice analysis that seems to me that would follow in this case.
Your Honor, I see I'm out of time. May I answer the question?
Yes, you may.
Please.
Judge Wynn, I think you are correct. The Supreme Court said in Hinton versus Alabama, it's a reasonable probability standard. And in 2016, the Supreme Court in Molina-Martinez says when a defendant is sentenced under an incorrect guideline range, the error itself can and most often will be sufficient to show a reasonable probability of a different outcome absent the error. That satisfies the prejudice prong of the Strickland test, the reasonable probability.
And so where that goes is we've talked about the guidelines, but if those are accepted, it could potentially reduce that guideline by 10 years, which, at least when you're looking at it from the Strickland perspective, dealing with a reasonable probability, not a conclusiveness of more likely than not, or on any level of that level, it seems to me that's the way you look at this as to what this counsel did. And to put it in context, the counsel makes this and says, oh, well, we're going to rely on the bridge. Well, everything in the record that looks to me, bridge doesn't apply to this lady. I mean, it just does not apply. He doesn't know that. It is very obvious from this record. I don't know how you make it up that he knows that. It is very obvious he does not have a clue that this lady will not get bridge. He thinks that he's going to be able to say all these factors don't mean anything. It's because he thinks this is a model case for bridge. It is absolutely not when you look at the record. That's the problem. I heard you mention the word, I don't like the word ignorance on his part, but it seems like there is some level of incompetence here that's evident from this record. For a counsel to stand up and says, here are 8 factors. It wouldn't make a difference in the world if you did it on it, when clearly it would, because there's evidence supporting them. But even then, to rely upon the bridge as being your fallback, that's my strategy, is I'm now going to go to the bridge program. And everything in the record shows that this lady who has this, all of this, the nature of the offense and the nature of her distribution of it would not allow her into the bridge program. And I don't know how you get around that kind of, determination. It looks pretty rare to me, pretty much on his face. I don't know the experience of this counsel. We didn't get into all that, but it looks pretty patent that this counsel did not have a clue what he was doing.
Judge Wynn, I would agree. He did not know the requirements of the bridge court. He states it on the record, and he actually appends documents to his filing, his improper filing, in his own email showing he didn't know. So could not be more clear in this case based on the bridge as well as the objections that he satisfies the requirements of Strickland.
This is the problem here, counsel, is a long-range one that I have, and we're focusing mainly on the performance prong of Strickland. And even though a lot of lawyers fall on their sword for one reason or another in order to help their client's case and say, yeah, I was ineffective or whatever, it remains a professional stigma, I would think, to say that someone was ineffective. And I worry about doing that without ever giving the accused lawyer even a chance to defend himself or herself. That seems unfair to me, and it seems to me a violation of due process that you say we're going to tag you with this opprobrium and compromise your professional reputation without ever giving somebody a chance to be heard. You know, I mean, I would think a court of law such as we are would want to pay a special appreciation to due process in any attorney disciplinary proceeding. We always ask for responses, and you know the point is you may well prevail on collateral attack, and if you do, you'll get a resentencing. But there's something basically unfair about attaching this kind of negative mark to a professional's reputation without ever giving the gentleman a chance to respond. That's my problem with it. I'm not holding this individual up as a wonderful practitioner, and I'm not saying he didn't make a lot of mistakes, but what's to be lost just by providing notice and an opportunity to be heard? And that seems to me so basic to what we do.
May I respond?
Yes, you may.
Okay. Your Honor, I understand the concern for counsel's reputation. However, I would like to present the flip of that here. First, the Supreme Court and the court says we can do this on direct appeal. But also, in this instance, it's important to note that if we were to wait until this were handled on collateral attack, and I think it would be found that the counsel was ineffective, there's a real harm to Ms. Freeman in this instance. If the court decides this on direct appeal, Ms. Freeman will be entitled under the sentencing guidelines to have her sentence run concurrent with her North Carolina sentence that related to the obstruction of justice enhancement under 5G3.1b. And she would receive credit for the time already served under that provision. However, her time in North Carolina is going to expire in early 2022. So just simply due to the passage of time, and this is an unintended consequence of this proceeding through direct appeal, if we now wait for her to have this heard on collateral attack because we're concerned about the counsel's reputation and an opportunity to defend himself, she will lose the ability to have these sentences run concurrent, which means in order to protect counsel's reputation because of his error, she's going to serve.
I want to join in Judge Wilkerson's statement, and because I think his focus is, in terms of the counsel's reputation, has a lot of merit to it. I tried a lot of cases. I know what it feels like to be in these places, and your reputation's on the line. But I think at the end of the day, this is about a defendant who has received a sentence and who, based upon the record before us, it is quite clear that he said some things in that trial that's right on the record that are absolutely wrong. And while his reputation is something we want to be concerned about, it is Ms. Freeman who's sitting in jail right now is what this case is about. He may get a chance at, to defend his reputation before a state bar if it went that far. And I'm not saying it should. I'm not saying that at all, because I don't know the circumstances. But I'm only saying that in this instance, we are dealing with a Strickland type issue here, and the question is whether or not this is rare enough. But when a counsel stands up and says, it wouldn't make any difference if she prevailed on these factors, when in fact patently it would make a difference, and then he focuses totally on a program for which she almost conclusively, if not conclusively, cannot qualify for, and he puts all his eggs in that basket. I'm with Judge Wilkerson on reputational, but this is that rare case, I think.
But I can say, let me just say this, that I'm not sure it's the rare case, because the same argument, counsel, that you just ably made, and that my friend Judge Wynn made, that can be brought up in every situation, because collateral review always delays the ultimate sentence. And you can say, well, we need to do this on direct appeal more and more, because collateral review is always going to increase the time of incarceration and is going to work to the detriment. So I'm not sure I see the limiting principle to what you're saying, because if delay is the reason for the prospect of delay, which adheres in all collateral proceedings, is going to be the basis that we resolve these claims to a greater extent on direct appeal. I just think we are ultimately losing something, and I've been on so many instances, sat on so many cases where something is posed as the rare case, and then down the road it's thrown up again and again and again as a case that's not so rare after all. I worry about traveling a troubling road.
And if I may address that very briefly.
Yes. Ms. Metcalf?
Yes, Judge King.
This is a rare situation when we grant the relief that you're seeking here. Ineffective counsel direct appeal, but we have done it correctly. I'm correct to say that, right?
We have done it, Your Honor. That's correct.
How many cases have you identified where the Fourth Circuit has granted relief on direct appeal for ineffective assistance of counsel?
The main published opinion is Judge Butzner's decision from 1973 in the Fisher case. There are a number of unpublished opinions, Your Honor.
All right. How about published opinions? How many published opinions?
There is one published opinion that I can find, and that is the Fisher case. It has also been done by a number of our sister circuits.
All right. Here, let me give you one from the Fourth Circuit. United States versus Russell, 221 Fed 3rd 615, 2000, Fourth Circuit 2000, that I authored. Does that help you? And Judge Widener agreed with me. There's another one for you.
Thank you, Judge King. I understand your research skills are far superior to mine, especially when you write the opinion.
I happen to remember the case. I happen to remember
there's another reality to that in terms of the number of unpublished opinions, and maybe it's just my observations, but we as a court tend not to make published cases like that. I mean, because they are so rare, you don't want it to become. I'm just offering that maybe they could have been published or not published, but that seems to be a way in which we do things around here. And so when you come up to say that it's unpublished, meaning really doesn't have any precedential value, it does have some at least persuasive weight to it. But that's just a policy of the court.
I would just think that taking this step in an in-bank proceeding would carry more than the normal weight in the future.
it would.
All right. Very well. Mr. Watkins?
Good morning, Your Honors. My name's Bill Watkins, and I'm representing the United States in this matter. Your Honors, in the last 10 years, this court has been firm and it's been consistent in holding that it cannot conduct a meaningful appellate review in sentencing matters without a developed record. Carter, Blue, Slappy are examples of such precedent. Your Honor, in this case, and consistent with this precedent and the spirit of it, all the government is asking is that this court allow Ms. Freeman, her trial counsel, the government, and the district judge to fully develop this record on this matter of ineffective assistance of counsel. In the district court, we can have affidavits, we can have testimony, cross-examination, written interrogatories, and some of the very good questions that Your Honors have asked will be answered.
Mr. Watkins, why do you need that in this case? There's no better example and evidence of what a lawyer means than what she or he says and does. He waived all the objections, then he came back with a civil motion, and if you read the motion very carefully, he didn't even understand the withdrawal of the objections. It seemed like he thought he still had preserved them because they were mentioned in the record. I mean, so how do you, what would you say and when you talk about give someone a chance, it's clear. It's absolutely clear. He just did not understand it. I mean, how do you clean that up?
You all think the record has multiple inferences in this case. For example, Ms. Metcalf is very quick to cite, as I would be if I were in her shoes, page 108, where Mr. Smith makes a statement that none of those objections reduce the number relevant to this court. However, if we turn back to page 107 and get context for that statement, for example, Mr. Smith says that he's discussed the relevance of the objections with his client, and with regard to the big picture, the objections are not going to change what the charges are, and that he believes that drug court or some arguments made in favor would be more pertinent. And then he goes on to say, we don't think that takes away from the vast number of pills that the government has accused her of dispersing or acquiring. Clearly, Your Honor, when he's talking about the number, he is talking about the vast number of pills. Whether we're dealing with a drug weight of a level 34 or a level 32, his client is in a bad spot because of the vast number of pills. And Your Honor, if we turn also to page 117.
I mean, he said wait a minute, counsel, she's in a bad spot because he's given up all the objections. If he had pursued it, in this case, he could have argued that she should not have been accounted more than 52,000 in this case. And it would have changed a swing of almost 6 to 7 points. I mean, total, if you look at just part of that when you look at the obstruction. And for example, obstruction, because in this case is, let me say this way. You said the big picture was bridge. Right? This is why this record shows that couldn't be a strategy. You've seen the PCR report, haven't you? Right?
Yes, sir.
Do you see anything in there that counsel even put to support his client's position about mercy? You have to figure out that during this time that she fled, she had a baby. She was homeless, she was evicted. You would almost like they just hide, she had a baby. She went to her family, had a baby. She had permission to go there, to go to church in that state. When you load up the PSR with that information about her, nothing about that at all. Nothing about her, because in your brief, you keep saying her assertion of addiction. He left the record where you could say something like that and didn't even put those things in there. It was clear. It's not even in the, so even if that was his big picture, he didn't even make a case for any sympathy in this case. And he gave up every every objection. And then we know he did it not knowing the law, because he came back with a civil motion to try to restore them and didn't understand what the impact was of removal. He thought it was still before the court. No, that's why the court looked with astonishment. You want to do what, counsel? Are you sure? Oh, wait a minute, let me ask this again. The only way to believe that this is in it is not to look at the record. How do you get around that? My goodness, why do we prop up lawyers when it's the Constitution protects the accused?
Your Honor, first of all, you have multiple questions. First, Your Honor, respectfully, Ms. Freeman was in a bad spot, not because of her lawyer, but because of her own choices. She chose to leave the jurisdiction without permission. She chose to be gone 6 months after her probation officer, a week after she went to Shelby, told her to return. She chose to engage in new criminal conduct. She chose to smuggle drugs into a local jail after she was apprehended. This because of Ms. Freeman's conduct that she was in a bad spot, Your Honor. Secondly, as regard to the record in this case, Your Honor, as I said on page 117, the lawyer again points out, in the big picture, nothing is going to change out of those objections. The fact that she is an addict and opioids have consumed her life. Again, when he's talking about the number is not going to change, he's clearly talking about the number of pills. He obviously knows that if he were to have been able to win an objection, the guidelines go down. He spent a lot of time calculating the drug weight based on the prescriptions and discovery as shown from his objections and his motion to reconsider, and he calculated a level 32. What's obvious here, Your Honor, from the record, as well as his statements and his motion to reconsider, is that he realized that he did not want a confrontation with the case agents, with the probation officer, where there would be terrible testimony for his client about her continued criminal activity, bad behavior while on bond, when he had no chance of winning very frivolous objections. He made a strategy decision that he would focus on the mitigating and on the positive. And Your Honor, again, respectfully, I disagree that we have to tease that out of the record. I think that lawyer made an excellent presentation that humanized Miss Freeman, that she had a great addiction in his terms. He goes back to 2000 with her having a fall, talks about her children, talks about how she could be a great force in the community to teach others, goes into her family situation. Your Honor, obviously, the district judge did not buy all those arguments. And again, I understand, but that's not unreasonable to focus on the positive, because, Your Honor, he could have, say, won one battle. I disagree that he could have won a battle on the objections, but he could have lost the war when all this horrible testimony comes in about her misconduct and opens her up for an upward variance, possibly from the district judge. So I don't think that we have a record that conclusively shows ineffectiveness in this matter.
Counsel, I expect you to argue that, but it turns on any kind of reasoning. I mean, I practiced law for 20 years. I did criminal defense work and other. To say that this record represents counsel was effective I read your brief, so that's why I didn't really ask you this question, because I see you're going to be staying there, but you can't justify this. You can't justify that this is anywhere near effective. The judge didn't do anything but accepted the PSR guideline because he accepted what they put in there. It was nothing. He gave up all of the objections. And the guideline for the weight, if it was 52,000, it wouldn't even be the top line of the 210. It wouldn't be. So, but I understand. I mean, that's your job. I'm not going to criticize you for doing your job, but to say we have to delay here, this is clearly. And for example, why in the record did you not even put in that she had a child during that time? It's almost like you said, well, she fled and she went on. Did you know that she had a baby?
Your Honor, probably was aware that she was pregnant at the time. But, Your Honor, I've had defendants have children in prison before. That's not uncommon. If you're a
Well, I'm sure you have, but we're talking about obstruction of justice, but she never missed a meeting at all. And he gave up the objection. But she said, look, I tried to reach her. So he gave up all of that. She didn't have a chance. If she had not gotten that obstruction of justice, she would have gotten her acceptance of responsibility. That's a swing of 5 points.
Your Honor, respectfully, there was a warrant out for Miss Freeman. The probation office, at the judge's directions, instructed her to come back to South Carolina. And it's from her own words in the record, as well as her counsel, she decided she wasn't going to obey that court's order because she didn't want the Department of Social Services involved, which the court had directed regarding her children, and she didn't want a child possibly born in prison. Your Honor, she just disregarded the court's instruction, and there was a warrant. There was a proceeding, Your Honor. As we've cited in our case, a warrant is a proceeding when the judge instructs her to come back. Your Honor, Miss Freeman just thumbed her nose at the court. She did not
thumb her nose by your own statement. Is thumbing your nose to say I'm concerned about my baby? Is thumbing that she's just had a baby, she's in postpartum, and you saying that's thumbing your nose?
Your Honor, she had not had the baby yet. She was pregnant at the time, but I would be thumbing my nose at this court if I decided not to show up today to argue the case because I wanted to do something else when you have ordered me to do so.
But I tell you one thing, if you showed up and showed a medical reason, it's unlikely that you would say you obstructed justice by not being there. That's the difference. She was treated like this didn't matter because he gave up everything. That's why the judge looked at him and said, "Are you sure?"
Counsel, I have a
Your Honor, she hid out from law enforcement for 6 months.
Judge Harris has a question. Yeah, go ahead.
Sorry, it's Judge Rushing. I'm sorry.
I'm sorry, Judge Rushing. I'm sorry. I thought I saw Judge Harris.
No problem.
I don't see you.
I'm on the phone, counsel. I wanted to ask about the acceptance of responsibility, because I know that's connected in some ways with the obstruction. How does the acceptance of responsibility argument tie into, you mentioned, I believe when she was captured after she was gone for a period, she was involved in other criminal activity. Is it related to that, or is it related to attempting to smuggle drugs into the jail, or is it both of those that relate to the acceptance of responsibility?
Your Honor, in the PSR, which the district judge adopted, so he adopted the findings, it was based primarily on her flight from the district and refusal to come back. But as Your Honor well knows, this court can affirm on any ground appearing in the record, and I feel very comfortable by saying that no district judge in the District of South Carolina would have given this individual acceptance of responsibility after she was smuggling drugs in a jail, picked up new charges.
In the record right there, patent evidence, this woman is addicted. And we've said this counsel didn't know any better. He probably thought what someone who hadn't read in the law would think. And that is, someone like this lady is just what the Bridge Court ought to take up. You ought to take up people who are addicted and came into it innocent. They got prescriptions and they became sick. That's not the state of the law, unfortunately. He did what someone on the street would do, and not as a lawyer in this type of a case. So I think when you look at the context of it, we just cannot, it just doesn't feel good to me to say she's done all these things. I agree. Legally, we are bound to do certain things. But we cannot, and I will not, approach this case as though this lady is just a hard-nosed criminal from the day she's born and just been mean-spirited and evil, when the inception of this started with a legal prescription that was given to her when she was pregnant the first time, and she fell for pain and she became addicted. And I haven't seen yet where that source has been addressed by anybody. And again, it doesn't, I mean, legally, it's not going to keep you from getting convicted if you go and sell it to other people. But that's the basis, that's the genesis of it. And I don't think we can escape that when we view this case, regardless of how we do it. We can be harsh all we want to in terms of saying the rule is a rule and we're going to do this. But this nation is facing this problem on an epidemic level. And it's not just this woman. In this instance, she's doing drugs. There are people who've done this. They've killed people. They've done all kinds of things. They've ruined their families based upon the inception of a legal prescription that caused them to be addicted. We know right now there's civil cases going on right now punishing people who did that. And somebody is responsible beyond this lady for what she's doing. To say she knew better, she's addicted. I mean, it's like saying an alcoholic knows better than taking a drink, which we tried to do in the Virginia case, you know, but this is a problem. And I'm not saying it changes the legal outcome, but to take that hardline view that she's just horrible, that's, to me, seems unacceptable in this case.
Your Honor, I would not say Ms. Freeman is horrible. I would say she's done horrible things. For example, if you were to accept her statement alone that she was selling 500 pills a week to individuals, it's a terrible thing that she is putting out that number of pills on the market for other people.
We are in agreement on that. And I'm not, that's what I want to make clear. We're not saying she didn't do horrible things under the law. But I want to make it clear that we don't accept this in a vacuum. This woman is sick, and she got that way from a legal prescription that probably shouldn't have been given to her. She became addicted. And then these horrible things happen. But I'm not going to argue with you. You and I agree. These are horrible things she did. I agree.
Yes, sir. And Your Honor, it was a tremendous number of pills. Again, from a human perspective, is this a very sad story? Absolutely. Is that perhaps something with regard to the drug laws that our policymakers and the national legislature might want to consider? Absolutely.
It's
However,
probably something that the sentencing court would have wanted to consider more had her counsel at sentencing done his job.
Your Honor, I think he did an excellent job of bringing up her addiction and highlighting that to the court. And he talked about the civil suits against Walgreens and other pharmacies, sort of in line with what Judge Wynn has made some excellent points on. Judge Thacker, he raised those. The district judge obviously heard him, but he obviously saw that the other factors outweighed that. And indeed, Your Honor, the guidelines in a departure situation make clear that addiction is not a proper grounds for a departure. It typically means it's more likely that that criminal defendant is going to be a recidivist. So, and many courts have found that addiction is not a mitigating factor per se, but it's aggravating. So I do understand the great points Judge Wynn made, and I think many of them go more to policy. But however, this district judge, along with what you on this court have been telling district judges to consider individuals, to carefully evaluate the sentencing factors, he did so, Your Honor.
Mr. Watkins, I have a question to Judge Diaz here. So there's been a number of references to the strategy of trying to divert the defendant, in this case, to the bridge program, the federal court's drug court program. And it seems pretty clear, maybe you take issue with this, that the defendant was not a likely candidate for the program. And so if we start from that proposition that the defense counsel just was mistaken about the likelihood of success with respect to this being admitted into the diversionary program, don't we then look to see whether or not the strategy of essentially treading lightly with respect to the enhancements was in fact a reasonable strategy? Because of that, you know, if he didn't have the option of the diversionary program, his only realistic option was to try to reduce the guideline sentences to as low a level as reasonably possible. And if that's the case, didn't he fail miserably in doing that?
Your Honor, I don't think there's any evidence in this record of statistics or anything that would tell us the acceptance rate to this bridge program, whether individuals with such and such drug weight, the odds that they get in and that type thing. What we do have, however, is information that if you're not a violent person, you didn't have a gun, you're certainly not disqualified from that. And as the district judge pointed out, it's in the district judge's discretion. He never ruled that she was procedurally barred because of whatever reason. The government never made that argument. Everyone on this record went into this sentencing proceeding on the proper assumption that this judge could have put her in the bridge program had he decided to. But he held that this would not be appropriate in this case, Your Honor.
So, counsel, if we should make an independent determination here, looking at the record that was before the court, that it was extremely unlikely that she would meet the qualifications for the bridge program, then what would we conclude about the rest of the representation that her counsel gave you, which I thought was the source of Judge Diaz's question to you?
Judge Motz, I understand that's a hypothetical. As you know, I disagree that this record shows that she would never have gotten into bridge program. That just
you've
doesn't
made that
exist.
very clear. But everybody can read the record, right?
But as to your point, Your Honor, even if we assume you're correct on that, she would have never gotten in, I think from this record, we can still conclude it's sound strategy, again, not to bring out bad testimony from case agents and the probation officer, again, about poor decisions, bad actions that Ms. Freeman has made, continued criminal conduct, fleeing, trying to smuggle drugs into a jail, ignoring the court's order. And I think it's reasonable to try to limit that. Yes, Judge Harris.
Can I ask you a question? And I also am going to ask you to assume a hypothetical, which is that as I read what I think we all agree is the most troubling sentence, where he says, look, none of my objections go to the ultimate number here. And I read that as telling the judge none of my objections are going to affect the guidelines calculation. Isn't there a difference between a lawyer not raising an objection for some of the reasons you've given and a lawyer, and again, hypothetically, affirmatively and incorrectly assuring the judge, like, you don't need to worry about any of this. You may have had questions about the drug weight, but don't worry because it doesn't affect the guidelines calculation. That seems like a different kind of attorney error.
Your Honor, if I understand your question, I would agree that if page 117, this lawyer we can conclusively say that he believes if he wins an objection, it's not going to affect the guideline calculation. We've established ineffectiveness, and your next inquiry is prejudice.
Okay.
Mr. White,
and can I say just a quick question? Oh,
yeah, go ahead.
Just a very quick question on prejudice. What would the hearing be for on prejudice? If the record conclusively proves deficient performance, why do we need an evidentiary hearing on prejudice? What sort of evidence would be put in?
Well, Your Honor, I would think there would have to be factual findings, for example, on the drug weight issue. With Ms. Freeman, her assertion that that is an error, that she, could have never reached a level 34. Again, we would have to hear from her. We would have to do new calculations there.
Seems like that's all sort of a legal question, whether on the record in front of this judge at this time, there was a reasonable likelihood that the objections would have prevailed. I don't know that you would take additional evidence that wouldn't have been in front of this sentencing judge, right? Like, I don't understand. It's not important.
No, ma'am, it is important, and let me answer that. For example, Ms. Freeman contended in the record at one time, that her statement to DHEC investigators about passing sometimes or successfully filling 21 prescriptions a week, and on a bad week only doing 7, that she contends, well, didn't I say that was just attempts? Well, that's not what is in the 302 or MOI, whatever we want to call it. For example, we would have testimony to see if those investigators, if that's what they recollected, if they have a recollection, is that what she said? Cross-examine her on issues like that. Those are the type issues that the government believes a hearing would help.
Okay.
Mr. Watkins, let me ask you this. Yeah, I do. The other part of this appeal is whether we can deal with a sentence as being unreasonably procedural or substantive if it's within the guidelines. This sentence is obviously within the guidelines. Under what circumstance could this court undertake a review of a sentence, like in this case, it's fairly extreme, if the rule is a presumption and not a per se rule?
Judge, for example, my research has indicated most often when we deal with substantive reasonableness and there's a determination a sentence within the guidelines was substantively unreasonable, it's in the child pornography area. And as your honors well know, Congress themselves crafted that guideline is in effect and not the Sentencing Commission. While I'm sure it is indeed possible, perhaps in other circumstances, Your Honor, I have trouble coming up with a good hypothetical outside that child pornography guideline, especially when that is the guideline where courts have found sentences substantively unreasonable. The Sentencing Commission does a good job, and I think that's the result. So, Your Honors, on to this substantive reasonableness point, Ms. Freeman hinges everything on one sentencing factor, and she attaches many nice graphs and things in there, but I believe we have apples and oranges. For example, on one of the graphs on page 24, we're dealing with offense level of at least 30. Well, Ms. Freeman had a 36, much higher than that. No weapon enhancement, and then a certain drug weight.
Let me ask a question before you leave. Maybe it's just off the record or whatever. I just am curious. It appears as though she must have had, they say 4 children, and maybe I guess 2 of them were born before she had that fall, and then they got their legal prescription on it. And beyond that, there is just a nagging question, maybe to me as appellate judges. How in the world is this lady able to write all these prescriptions over a course of quite a long time under what clearly has become an addiction after the first legal one is given? She's complete, and she gets in the court process. Is the system so loose that someone can write prescriptions on this level over and over again? And I'm just wondering, in terms of, we don't let alcohol people who sell liquor to minors or whomever, over and over do it. I guess they can to alcoholics. I'm just curious, how was she able to do this?
Well, Your Honor, the evidence in the record shows that she worked at a physician's office. She was able to get prescription paper there, as well as from unnamed individuals. According to her interview, she was able to get physician DEA numbers.
I guess, and I'm just in it. It just seems like to me, there are a lot of other defendants ought to be in this matter. Anybody who lets prescription pads lay around so that even the workers can take them, and then at the same time, this person, at some point, somebody has to know this lady is addicted to drugs, and continuing. I don't know if she gets it on the internet or whatever. It just seems to me there's a lot of other prosecutions here of people who dispense the drugs, because she's getting them from a legal facility, and apparently they have no duty whatsoever, at least what I'm getting here. Maybe there have been some other prosecutions, but this is a bad case.
Your Honor, to respond to your question, I agree. I've prosecuted a physician before in this area for prescribing practices and achieved a conviction. I think also some of the problem why she was able to do this is the state system failed her. Rather than a significant sentence to deter her from future criminal conduct, she received slaps on the wrist in the state system. That did not deter her. And here we are in federal court with a significant drug.
Or maybe getting her into the bridge program when it was not so severe might have worked.
Yeah, perhaps some judges would have put her in the bridge program just as on substantive reasonableness. I would not be shocked if we might have 10 different sentences for Ms. Freeman from this distinguished panel. There's a continuum of reasonableness. It could have been a little higher, could have been a little lower.
But counsel left the judge with no spectrum at all, but just everything in the PSR to accept it. That's all the judge basically did. And as to the other, he said the 3553 factors and the guidelines, you've already removed all the objections. That was all was left because of what he did. He gave up every objection, every one, and didn't even understand the impact of it. So the judge was left with just that. And the judge never explained why he didn't put her in the program. He just didn't. And because he looked at the 3553 factors, because he didn't have to do anything with them. They were not opposed. As a matter of fact, didn't she have 5 children?
Yes, sir. I believe that's correct, Your
And
Honor.
the PSR said she had 4.
Yeah, that might be an error in there. I didn't catch it. You did.
But
Your Honor,
neither did her defense attorney.
Right. He didn't do anything to put those things in the PSR. No counterweight at all. This lady was bereft of counsel, basically.
Your Honor, he came up with a counterweight of a level 32 after close scrutiny of the prescriptions produced in discovery. But there is a clear inference that he made a strategic decision, which this court should give wide leeway to counsel to withdraw those. So in his words and Ms. Freeman's words, to avoid the hostile environment that this bad testimony would bring.
And that's why he attempted to bring them back up. The same objection. He tried to resurrect them. So we know it was no strategy. You can't just turn a blind eye to the facts.
Respectfully, he was in a position after losing that motion to play Monday morning quarterback. So what did he have to lose by bringing them up at that time?
Oh my goodness, you got an answer for everything. But the truth is, if you look at it, he didn't understand exactly the impact of his waiver. It seemed like he thought, well, it's still in there. It's before them. I mean, if you read it carefully, it was went very well. Yeah, anybody else have any questions? Thank you very much, Mr. Watkins.
Thank you, Chief Judge Gregory.
All right. Ms. Metcalf, you reserve some time.
Thank you, Chief Judge Gregory. If I may, I'd quickly like to circle back to Judge Rushing's question and consider it in the context of Judge Wilkinson's questions in my original argument. Judge Rushing had asked about the acceptance of responsibility and the impact of the new charges. And this is important, and it goes back to my point about why this is a rare case that needs to be now decided on direct appeal instead of waiting for the collateral attack in an evidentiary hearing. As counsel for the government stated, Mr. Watkins explained, the court can withdraw her acceptance of responsibility based on the fact that she has these North Carolina charges. It's referenced in the PSR, and the government has stated that that's a basis for her to move her acceptance of responsibility and potentially to have an enhancement for obstruction of justice. Under 5G3.1b, she's allowed to run that North Carolina charge concurrent with her federal charge. And she's also allowed to have credit for the North Carolina time that she served, which has been about 3 years since this case since judgment was rendered, as long as there is an undischarged amount of time left on that North Carolina sentence. If this court rules on direct appeal, there will be an undischarged amount of time left such that she can run the sentences concurrently. However, at this point, and it's just an unintended consequence of the passage of time, and it's very unique in this case, if we wait till collateral attack, the North Carolina sentence will expire, and she will therefore serve an additional 4 years of the North Carolina time on top of her federal time, because we waited for collateral to address this on collateral attack when we could address it on direct appeal. And so that's an important aspect in this case that makes it very unique and helps balance the equity between the harm to the counsel's reputation and this person's constitutional right to effective assistance of counsel. That's an additional 4 years that she's away from her children if we wait to address this on collateral attack. And we don't need to wait. This case is ripe for consideration. The record conclusively reveals that Ms. Lawyer had no strategy.
But just to clarify, so were you agreeing with the government that the additional charges and the smuggling would have prevented her from receiving an acceptance of responsibility reduction?
I'm not agreeing that. I believe her counsel should argue it on resentencing. It's very important, and it's not a clear question in this circuit as to whether or not she would lose the acceptance of responsibility or obtain an obstruction of justice enhancement. I disagree with Mr. Watkins' statement that every district court judge in South Carolina would give her the obstruction enhancement. However, under the current pre-sentence report and the guidelines as adopted by the district judge, she has lost the acceptance of responsibility and has an obstruction enhancement. And if that stays, by the time she goes back on collateral review, her North Carolina sentence will have expired and she will lose the ability to have credit for the North Carolina sentence unless we address it today on direct appeal before the court today. So I'm not agreeing, no, Judge Rushing, with the statement that she should lose the acceptance of responsibility.
So you think that a judge, that you can show prejudice on that prong, that a judge it likely would have accepted that acceptance of responsibility reduction and not given the obstruction enhancement, knowing those facts?
I think there's a reasonable probability that the district judge, had this been argued by competent counsel, could have found that the loss of the acceptance of responsibility points was improper and that she should not have lost those points. The guidelines, the comment to the guidelines actually contemplates this and says that in exceptional circumstances, and as Chief Judge Gregory and Judge Wynn have noted, this is one of those exceptional circumstances. In exceptional circumstances, the loss of acceptance of responsibility shouldn't apply. And here it's exceptional because for the reasons that the court has already discussed. She didn't just flee. She didn't run to Mexico. She didn't hide out. She told...
Let me ask you something. Do we have any cases where we have found prejudice in circumstances where the prejudice depends on the discretion of a district judge? In other words, we would have to assume the district court exercises a discretion one way or the other, but has the discretion to go either way. Have we concluded that we can base prejudice on that circumstance?
I'm sorry, I lost the feed for a second.
The question is, do we have any cases where we can, where prejudice can be shown in a circumstance where we have to, it depends on the exercise of discretion by a district court?
The Sturdivant case from earlier this year involved a similar situation where, and this court found ineffective assistance of counsel where counsel withdrew a meritorious objection. So to the extent, what you're asking is whether the court's determination on an objection, if you consider that to be discretionary, then yes, we do. From this year, the court issued an opinion in the Sturdivant case. But again, it's not discretionary because he withdrew these objections. The court didn't even get to rule on them. There was no...
No, the court was fully aware of them. it's easy to trash this lawyer because he made so many mistakes. But on the positive side, he made a very effective appeal to the circumstances of his client. He spent pages talking about her conditions along the lines that Judge Wynn had suggested. And the judge expressed a full awareness of the objections and said he was prepared to hear them. And so he knew what was being faced there. And then the judge went on for a pretty good paragraph saying why he had thought this 210 months was the right sentence, despite those calculations, because it focused on the 3553A factors and said, this is what I think in the circumstances of this case should be the right sentence. So now we have all these, the judge's awareness, and there's a lot of discretion being exercised there. The judge did go to the bottom of the guideline range, but as others pointed out, that sentence is also within the guideline range of a 32 level. But my main question is a legal question as to whether we can find prejudice in a circumstance that depends on the district court's exercise of discretion.
Your Honor, I'm not sure that, again, these are rare cases. I'm not sure that I'm aware of a Fourth Circuit case that is directly on point to your question. However, the Supreme Court's case law in this circuit's case law has said that where a counsel's ineffectiveness exposes the client to a higher guideline range and a longer sentence, that is evidence of prejudice. And in this situation, his error—
I know, but that's totally different. That's not hard. What's hard, I think, is when it depends on the exercise on your prejudice depends on the exercise of discretion by a district court. And the district court has expressed the reasons for why it did exercise its discretion in this case, which is irrelevant to the objections made. The court was basically impressed by how long this drug business was going on. And of course, while she had an addiction, and it's a sad case for her, she passed it on to other people trying to get them so addicted so as to create business. And she pointed out how her business was yielding $1,000 a week profit. And so she was beyond just feeding her addiction. She was running a business. And the business is what troubled the district court a lot, the extensive period of time that this was going on as a business. Sure, she was addicted and she was supporting it, but we have a lot of drug dealers that are addicted and supporting them, supporting their own habits. But the problem in this case is that her own conduct is also now creating addictions for other people on a very large scale. And I think the district judge expressed that quite well. And so it's not, I don't think we can just dismiss it that the court would have automatically given her a big break had he argued these objections.
And Judge Niemeyer, I think my only response is to refer you back to Judge Harris's question. It doesn't really make sense why in this situation the district courts made that comment about I would have sentenced the same way or exercised my discretion because there were no objections.
He explained why. He spent a whole paragraph explaining why. It wasn't just a rote thing. He went right to the 3553 factors and said, I'm familiar with this case, and it's based on the facts of this case. And he explained what they were. So we're not lacking the reasons why he did it. The question I'm asking is, had the three objections been argued? You have number one, would have he sustained them? And two of them at least require discretion. The other one requires some fact finding. And number two, would it have changed the judge's mind? The judge said he would impose a variance sentence, he said, because I think 210 is the right number. That's what the judge said. So these are fairly difficult, I think, in carrying a burden of prejudice when it relies on the discretion of a district judge who's revealed his views about how the discretion is going to be exercised. I know that's more of a statement than a question, but if Judge Gregory is agreeable, I'm happy to have you respond to that.
Absolutely. You may respond.
Can I interject, Judge Gregory? Can I interject with
yes, Judge King.
As I recall, under Strickland, to establish prejudice, there has to be a reasonable probability that, but for counsel's unprofessional errors, the results of the proceeding would have been different. A reasonable probability is the probability sufficient to undermine confidence in the outcome. Well, that's what the Supreme Court said in Strickland as to the prejudice problem. And I don't think that's consistent with what Judge Niemeyer's talking about. Now, that's not a question, but I interject that.
Thank you, Judge King. Ms. Metcalf, you want to respond to Judge Niemeyer further?
No, I'll just say that I agree with Judge King. I think Judge Niemeyer's questions with regard to discretion are articulating a different standard that goes beyond what the Supreme Court.
It's a misunderstanding, and I think it's important for me to make my question clear. It's not the probability or not. Judge King obviously stated it very correctly, and I agree with that. The question is, how do you carry a burden of that probability when it depends on the discretion of a judge, and the judge has already indicated how he's going to exercise that discretion?
In this case, and this is why it's the rare case, you carry the burden because you establish that but for his withdrawal of meritorious objections and decision to put all his eggs in a basket with no bottom for the bridge court, the starting point for the offense level that the judge based his 3553A factor decision off of and his discretion would have been different. So before you even get to the discretionary portion of the district court's decision,
well, it would have been different only if the judge agreed. In other words, on the drug weight, I think the record I would predict that the judge would have stuck by that weight. But the most that your client would have gotten would have been from a 34 to 32, at least based on the calculations of your former counsel. But on the other,
may I raise just a brief
on the other two, there's no suggestion that judge would have given discretion to grant them.
Counsel, may I raise a question? One thing that concerns me is not so much this case, but where we are going. If we agree with you, aren't we pushing lawyers to be objecting here and there and everything? You've got an in-bank decision that's saying these failures to object, no matter what your reasons might be, will give you an IAC. Are we pushing lawyers to be objecting in sentencing hearings at the drop of a hat? Even when the attorney, as well might be possible here, feels that it is profoundly not in a client's best interest to be objecting here and to be objecting there and the rest. And I don't know, it might be applying just to sentencing, but it might be applying to trial as well, because it's a job of a lawyer to assign priority to the claims that are made and to assign priority to the objections that are raised. And if we push lawyers at sentencing and perhaps at trial to say, look, if you let any kind of even arguably meritorious objection go, you're going to be hit with an IAC claim. And it takes the case away from the lawyer and has them raising objection after objection after objection. And I don't know that you can get away from the impetus that you're providing to an over-objecting lawyer and taking it away from the attorney's good judgment by saying, this is one of those rare cases. This is one of those rare cases. I can tell you that the bar is going to read it as saying, we've got to object to every little thing. And that is not the direction you want lawyers in the circuit to go. You want them to exercise good judgment about which claims are important and which objections are important. And this goes contrary to all that, and in some ways to the very nature of legal representation. And that's, you know, you have to, when you get into these in-bank settings, have to look at the long-range signals that you're sending. And it's very hard, it seems to me, given what would be done, to sort of cabin this off as simply a rare case. That's
Your Honor, if I may quickly address that, the nice thing is this court is not being asked to set something new. That standard was already set by this court in the Carthorne case in 2017. In that decision, the Fourth Circuit said, stated the standard with regard to meritorious objections. So counsel who practice in criminal matters in the Fourth Circuit since 2017 have already been on notice. And so that was before Ms. Freeman's case, actually, that they needed to bring meritorious objections, and failure to do so might subject them to an ineffective assistance of counsel claim. Of course, it's balanced by the Supreme Court and the Fourth Circuit's guidance with regard to informed legal choices. And the Fourth Circuit since 1987 in the Hyman case says with regard to informed legal choices, lack of preparation and research cannot be considered the result of deliberate, informed trial strategy. And in this case, that's what we have. There wasn't that preparation and research and informed trial strategy. And that's why this case is different. But since 2017 in the Fourth Circuit's Carthorne case, this court's already said.
And the response is, without a hearing, how do we know?
In most cases, Your Honor, we wouldn't know. But in this case, we don't need the hearing, just like in the Fisher case, because the lawyer stated on the record repeatedly that he didn't understand the guidelines, he didn't understand the impact, and that he thought his client was eligible for the Bridgeport program, which she most certainly was not eligible for.
So
and that makes this a rare case.
Thank you, counsel. Ms. Qualabong, go ahead.
Yeah, and I'll be this is the last one little thing. Doesn't it also, counsel, put the district court in a difficult position? You know, if a lawyer withdraws an objection, I think you would agree that even a meritorious objection can be withdrawn based on strategic reasons. Yeah, I realize we're talking about the counsel's job and not the district court, but it seems to me you're also putting the district court in a difficult position, almost as if he's or she has to do some sort of evaluation of how strong the objections are. I really do think this has, you know, broad implications about about the practicalities of what lawyers do every day in making decisions and what district courts do when they make those decisions, and to do that without ever hearing from the lawyer. I mean, he may crash and burn when we hear from him. I mean, I'm not saying he won't, but that just seems like such a big step that I think we're doing. You know, we're going to create more. We're going to create a real conundrum in the practicalities of on the ground work.
Well, go ahead, counsel. I'm sorry, I'm about to say something. Go ahead.
Go ahead, Judge Gregory.
No, I'm not going to say it. Go ahead, because I shouldn't respond. But go ahead. You respond. Go ahead.
Judge Quattlebaum, I'll just say I believe the district courts are up to that challenge as demonstrated by the district court record in this case. I mean, I can feel the district judge leaning in, and where he says, listen to my question. The district judge in this case recognizes that there's something here that isn't right. Something smells rotten in the state of Denmark when he is withdrawing these meritorious objections. And the district judge here, I think, ably tries to address this issue. He asks repeatedly, "You sure you want to withdraw these objections?" He then asks Ms. Freeman. When Ms. Freeman says, "I'm not sure," and then asks the district judge a question, he has her step aside. So yes, there is a burden on the district court, but I think the district judges are very able to address that. And the district judge in this case demonstrated how it can be done. Thank you, Ms. Metcalf. Thank both counsel. I note, Ms. Metcalf, that you were court appointed. I just want to note on behalf of the Fourth Circuit how much we appreciate your doing that in very important cases. We appreciate it. And Mr. Watkins, I note your able representation of the United States. We can't come down and reach as we'd like to, but know very much that we appreciate your being here and wish you safety and wellness. Take care. And with that, I'm going to ask the clerk to recess the court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.